Welcome to Environmental Law course, dear learner, and we are in continuation to our lectures regarding the biodiversity conservation law. We have taken note of International Convention, International Biodiversity Law, and after having a panoramic outlook of the International Biodiversity Law in relation to Convention on Biological Diversity, Bonn Guideline 2001, Cartagena Protocol on Biosafety, and Nagoya Protocol 2010, we have taken note of the National Biodiversity Law in relation to the Biodiversity Policy of 1997 and Biodiversity Policy of 2000 and National Action Plan on Biodiversity. We have taken note of the Conservation of Biological Diversity Act. We have taken note of the Plant Variety Protection and Farmers' Rights Act. We have taken note of the Biodiversity Rule. We have also taken note of the Access and Benefit Sharing Guideline passed by the Ministry of Environment and Forest and Climate Change, and we have examined that what is the implementing mechanism in the second lecture, that law and administration aspect, and we have taken note of the three-tier mechanism of the biodiversity conservation, starting from the National Biodiversity Authority, State Biological Diversity Board, and Biodiversity Management Committee in relation to the biosurvey and bioutilization in relation to commercial exploitation and commercial utilization in relation to research utilization. And we have seen that how these three authorities are playing a major and pivotal role in the conservation of the biodiversity at one hand, regulation of the access of the biological resources on the other hand, the documentation and chronicling of the biological diversity resources on the another hand. By and we have also seen that how the communitarian approach of the biological diversity convention in giving effect to equitable and benefit sharing has tried to give a legal shape to India's traditional knowledge system and conservation of the traditional methods by the Biodiversity Management Committee, documentation and People's Biodiversity Register, and digitization of the traditional knowledge project. Having discussed all these things, now we are going to discuss about the adjudication of biological diversity dispute. And in this reference, as we have seen, the first and the foremost aspect of adjudication of the biodiversity dispute emerges out of the anomalies of Patent Act and Biodiversity Act. In this aspect, we have taken note of that whatever infirmities and anomalies have crept into the Biodiversity Act and as well as the Patent Act and the competing sets of claim as it has been identified in various case law and as well as in regard to the patenting of the biological resources, the conflict and congruency, how that is to be sought out, because this is one aspect of the biological diversity dispute which we have already discussed in detail while discussing the comparative role of the law and administration, and in that respect we have identified the issue of the compatibility and incongruency of the biological diversity as well as the Patent Act. We have tried to look at a broader picture in this regard, and that picture appears to be that how the legal and policy issues regarding to biological material which has been defined under Patent Act and how it has been defined in Biological Diversity Act 2002 are to see some kind of a common approach. So the ambiguity which has crept into the legal definition of the biological material under the Biological Diversity Act, and it has not been defined in the Patent Act 1970. So how it is going to be give rise to biodiversity disputes and litigations. And in that respect, we see that there is a need to harmonization, because in my humble opinion, this is going to be one of the major source of dispute, and that requires a subtle delineation and subtle adjudication. So having a need for harmonization, we have to make the biodiversity law compatible to Patent Act or patent law in conformity to the Biodiversity Act, and to that end, the proposed amendment of the Patent Rule 2003 and Draft Patent Amendment Rule 2015, which has introduced provision for handling application where permission of the National Biodiversity Authority is not obtained within the prescribed time, but the term appropriate order remains undefined and create further ambiguity and confusion. Therefore, what has been laid down under Rule 19 of the Biological Diversity Rule 2004, which requires prior approval from the National Biodiversity Authority before applying to intellectual property protection based on biological material and knowledge obtained in India, needs to be discussed in right earnest. And in this respect, the case law on the point, which have already set the tone of the reform and refurbishment of the incongruency and incompatibility in AKB Jagannath Nag versus Union of India. In 2016, the Calcutta High Court have tried to see the Section 6 read with Section 19(2) of the Biological Diversity Act in a very holistic perspective, while trying to examine the order which was passed by the Controller of Patent and Design and applicant seeking fresh approval by the National Biodiversity Authority, and it examined the Section 117A of the Patent Act, and it referred and observed very in a very pithy manner that the confusion which has been compounded, that as to which authority and which law has a precedence in matters of adjudication of the biodiversity dispute, whether it can be Patent Act 1970, or it is the Biodiversity Act 2001, or it is the National Biodiversity Authority at Chennai, or the Controller of Patent and Design in Mumbai. So we have to see very carefully what has been contained under Section 6 and what is it contained under Section 117. So both these sections requires a certain delineation, and when we are going to discuss about the biodiversity disputes settlement, then this case along with the legal regime and some advances which have been made under the patent rule and draft patent amendment rule 2015 needs to be understood in the context of rule 19 of the biodiversity rule vis-a-vis section 19(2) and section 6 of the Biodiversity Act 2002, so that the biodiversity dispute in India can be minimized and can come out of the purview of the Patent Act, because the moral foundation of the biodiversity law in this country adopts equitable benefit sharing model, which is juxtaposed to the intellectual property model as it has been ordained and handed down by the TRIPS agreement and the subsequent intellectual property instrument and law at international level. So the one dispute appears to be the anomalies of Patent Act and the Biodiversity Act, and the advances made in this regard have really going to resolve the biodiversity dispute that has to be seen with great care and circumspection. After that, we see that the nature of dispute appears to be number two is that the access to benefit sharing and access to the biological resources to foreign, to NRI, to Indian company, individual, firms, and body corporate, what kind of exemptions are given and what is the limits that have to be seen under it, and that exemption is to be examined, because in slide to be followed we will see that how in case of Divya Pharmacy versus Union of India, an Indian company wanted to seek an exemption from prior approval of the biodiversity board and have also failed to pay the required fee and wanted to share its benefit sharing with the biodiversity board. So that kind of a confusion is the another confusion of the indigenous companies versus foreign companies in matters of biodiversity governance and adjudication of biodiversity dispute. Having said so, these two cases are very broad in outcome. The one, the patent biodiversity dichotomy, and the another, Indian and the foreign entities dichotomy and its application of the biodiversity law and approval of the NBA or SSB or BMC. Having prefaced these two cases and two major sources of dispute, we will try to see that how Section 50 lays down the procedure for settlement of the dispute and how the settlement of dispute relating to substantive and administrative matters on biodiversity are dealt, how the dispute between National Biodiversity Authority, State Biodiversity Authority or board, or how the Biodiversity Management Committee is to be decided by providing reasonable opportunity to the parties. In this reference, the perusal of Section 50, subclause 6, which lays down the procedure for settlement of dispute, which envisages that the biodiversity, National Biodiversity NBA shall have, for the purpose of discharging its function under this section, the same power is vested as a civil court. So, NBA is not only a think tank, not only a nodal agency, but it becomes a quasi judicial body in matters of adjudicating disputes, having exercising the power of the civil court as contained in the Civil Procedure Code 1908 in respect to number one, summoning and enforcing attendance of any person, examining on oath, requiring the discovery of production and document, evidences and affidavits, issuing commission for examination of witness and document, reviewing decision, dismissing application for default or deciding ex parte, getting aside the order of dismissal, and any matter which is being prescribed by the law time to time. So, the role of National Biodiversity Authority, so far we have been discussing from the administrative point of view by discussing as a think tank because it has a provision of expert committee to guide on the conservation issue. Now we are moving from that to role to a quasi-judicial body which is permeated under Section 50, subclause 6 of the Biological Diversity Conservation of Biodiversity Act to see that how they are going to settle the dispute in an amicable manner. The procedure of adjudication of dispute, to that end we have to see the Rule 23 of the Biodiversity Rule 2004, and it lays in detail that how the memorandum of appeal shall state the facts of the case, ground relied upon, and how the relief is to be sought, how memorandum of appeal shall be accompanied by authenticated copy, order, direction, policy decision, and how the appellant as an aggrieved party shall duly be authorized by representative to appear, how the memorandum of appeal shall be submitted in quadruplicate either in person or through registered post or with acknowledgement, and how the notice of hearing of the appeal shall be given under the Form 6, how the central government shall, hearing the appellant and other parties, will dispose the appeal, and what are the guiding factor in disposing the appeal, how it can modify, cancel, and impugn order, direction, or policy by case to case basis. So, the substantive version of the biodiversity dispute has been laid down under Section 15, subclause 6, whereas the Rule 23 try to give a procedural version of the adjudication of the dispute. In case whatever has been laid down under Section 50, subclause 6, and whatever has been laid down under Rule 23 of the Biodiversity Rule 2004, if appellant remains dissatisfied to the kind of the relief and order by the National Biodiversity Authority, then the appellant, by way of natural justice, can file an appeal to National Green Tribunal, and any person who appears to be aggrieved by the determination of the benefit sharing, because this is one of the most litigated area, the royalty, the benefit sharing, the fee, the quantum of the benefit sharing, and how that benefit sharing are going to be distributed among the community. So, any question or any party who happens to be aggrieved by the determination of the benefit, then the party has a right to go by the National Biodiversity Authority or a state biodiversity authority under this act. Then after 2010, he may file an appeal to National Green Tribunal under Section 3 of the National Green Tribunal provision, and this is amended under the Biodiversity Act and inserted by the Act of 2010, Section 36, Schedule 3rd in 2010 in the Biodiversity Act in India. So, taken together, Section 50, subclause 6, Rule 23 and Rule 52A, this is the legislative framework of adjudication of the biodiversity dispute, and the manner of giving the notice as it has been contained under Rule 23 and Section 61 is also important, and what it says that this is the forum 7, that the manner of giving notice under section 61 should be in writing. So whereas we have discussed section 50, then we have to look at the section 61 of the Biodiversity Act and rule 24 in this regard of the notice under section 61B under Biological Diversity Act to the parties seeking explanation in regard to any kind of a document, any kind of an evidence, any kind of the biological resources, biosurvey, bioutilization for intellectual property, patent, these kind of the issue, and these are the ground on which the notice can be issued by the National Biodiversity Authority under section 61 in accordance with the form 6(7). The offences and penalties which are provided under the Biodiversity Act is also important constituent to understand the essence of the adjudication of biodiversity dispute. In this reference, we will take a glance over the offences and penalties which have been provided in the Biodiversity Act. We have culled out various sections, and then we try to see that what is the punishment, what is the fine, and what type of offences and categories are being built upon. To start with, we look at the penal provision and the penal regime which has been introduced in the Biodiversity Act. The violation of section 3 lead to an imprisonment of 5 years, and then we have to see that the violation of section 33, section 3 will also lead to a fine of rupees 10 lakh. If damages are being accrued, it can go to more than 10 lakh and commensurate with the fine plus prison of 5 years. And the nature of the offence of section 3 appears to be cognizable and non-bailable, whereas section 4, it also prescribes the same kind of the punishment. It talks of 10 lakhs or even more, and it is led to commensurate, meaning thereby here also we have indeterminate sliding scale. It's not decided a priori, rather it depends case to case, circumstances to circumstances, and violation of section 4 is also appears to be cognizable and non-bailable, whereas section 6 also prescribes the same punishment, same fine, same nature. Contrary to these three sections, section 7 is having a lesser kind of an imprisonment and reduction in the fine, but it remains cognizable and non-bailable. The violation of section 24 subclause 2 order will attract the imprisonment of 3 years or a fine of 5 lakh or both, and its nature also appears to be cognizable and non-bailable. Thus, we see for contravention of any order or direction of the center or a state government, be that National Biodiversity Authority, a state biodiversity board, or the Biodiversity Management Committee, created under this act that the first time offense is going to be 1 lakh, second subsequent offense is going to 2 lakh, and continuous contravention is extendable to 2 lakh per day basis. What comes out of the discussion and a overall perception of the penal regime which has been introduced under the Biodiversity Act, what comes out of the perusal of Section 3, Section 4, Section 6, Section 7, Section 24, it appears that the punishment under the Biological Diversity Act happens to be very deterrent, because no fine appears to be less than 5 lakh and it goes to 10 lakh, and even it can be exceeded by looking at the circumstances, and the imprisonment is also not less than 3 years to 5 years to 7 years. And as a miscellaneous provisions, any contravention of any order or direction by the biodiversity administration and governance will result into the pecuniary imposition of 1 lakh and 2 lakh and 3 lakh and 2 lakh on daily basis for continuing offences and habitual offences. Having taken an overview of the adjudication of dispute, starting from the biodiversity and patent dichotomy and Indian and foreign companies dichotomy, having perused the bare provision of Section 50, Section 61, Rule 23, looking at Section 52A, then the form of the notice and offences and penalties, we will try to examine the nature of the dispute which have come across to the adjudication and how disputes are resolved. We will be referring to Environment Support Group versus National Biodiversity Authority, which have seen its judgment from Karnataka High Court to National Grill Tribunal. This case is again that whether High Court or whether NGT is most appropriate to look at the issue of the biodiversity dispute. Looking at the judgment of the Environment Support Group, the High Court has is very reluctant to adjudicate on biodiversity dispute simply because of the existence of Section 52A. Nonetheless, what is important in this case, that the original jurisdiction of the High Court is in no way going to be compromised even there exists a National Green Tribunal. So the remedies which are being sought by the petitioner in this case, the High Court has probably missed an opportunity to look at the biopiracy case of brinjal jump plasm, and the bona fides of the petitioners were unnecessarily been dragged into from High Court to NGT. Moreover, the High Court has also not taken a very firm view by staying for 6 months the criminal proceeding against the non-Indian seed company who happens to default the basic ethos of the biodiversity conservation law. So we can have some kind of reservation about the High Court's relaxed opinion and view and its over-reliance on NGT to decide very judiciously on the very burning and substantive issue of the biopiracy of the brinjal germplasm by shifting responsibility to National Green Tribunal. In the case of the chess scientists, which have collected some insect in Singhalila National Park without the permission of the NBA, and since the wildlife protection has more criminological content than that of the biodiversity law, so on the strength of section 27 and 29, since it was a national park, so this law was validly come under that jurisdiction, along with section 3 of the Biodiversity Act seeking approval of the NBA was violated. Therefore, the Chief Judicial Magistrate have fined and also sentenced for 3 years imprisonment. However, the Calcutta High Court have reached to a very liberal view in view of the reputation of these two scientists, have taken and exonerated these scientists by mere admonition. The case, however, highlight the pace of piracy and the regulatory oversight that has to be taken into care within the regime of the adjudication of disputes of biodiversity. In a Japanese national case in Kerala, where reptiles were collected in Athirepalli forest without NBA's permission, also happens to attract Section 59 of the BD Act, and since there was a violation of Section 59, it appears that the Kerala High Court has also not taken a very serious view in case of access to biological resources without permission of the National Biodiversity Authority. The Planter Forum versus State of Kerala have raised alarm regarding the biodiversity vulnerability, and it talks about capacity building as well as training at the grassroots level, that means the BMC level and among the community, to see that the biological diversity's act, object and purposes are to be achieved by the biodiversity officials and the forest officials both. In Nathrani Island versus Western Ghat Archipelago group of island case, we see the Kerala High Court directed to implement the mandate of Section 36, Subclause 4, Subclause 1, and desired to constitute Environment Impact Assessment Authority. So, as we have the purpose of sustainable use, as we have equitable benefit sharing, as we have sovereignty over natural resources, so other purpose of the biodiversity law, the other important purpose of the biodiversity law is to apply the environment impact assessment. Therefore, in this case, has highlighted that in order to see an smooth success of this law, it is nothing but imperative to create environment impact assessment authority to conserve marine biodiversity. So, from the biodiversity to environment impact assessment, and from plain diversity to mountainous diversity to marine biodiversity was the point in this case. On the other hand, we find the NGT case on QT BMC of 2016, which has challenged the destruction of biodiversity and requested to seek appropriate remedy to protect threatened species and demanded some kind of a revenue sharing for the bioresources use, and the law as exists now and what are the ambiguity in the BMC jurisdiction that was highlighted to have a very viable and effective remedy to seek redressal by the common people or the local people under the BMC jurisdiction in biodiversity conservation adjudication of dispute. In North Bengal case in 2016, where the environmentalist Subhash Datta showed evidence of biodiversity loss and highlighted destructive activities, have triggered some judicial concern by its reinforcement for the ecological action under the biodiversity law of this country. The Environment Support Group versus National Biodiversity 2013, it says that whatever the court held that the biological diversity falls under Schedule 1, granting National Green Tribunal jurisdiction to adjudicate enforcement of dispute, was challenged, and the very constitutionality of Section 40 and sought to be quashed to 2009 notification, which resulted into abdication of power and transferring dispute to from High Court to National Green Tribunal, was questioned in Environment Support Group and versus National Biodiversity Authority. In Divya Pharmacy case in 2018, that is a landmark judgment in the sense that it has dwelled on the dichotomy what we have referred in the beginning, that major disputes in relation to biodiversity dispute and resolution come from number one, the anomalies of the Patent Act and Biodiversity Act, and the another source happens to be the Indian versus the foreign company, and the petitioner was of the view that the Indian company appears to be exempted from seeking approval of the National Biodiversity Authority or a state biodiversity authority in matters of access of biological resources. And moreover, the company was not willing to share its resources under the equitable benefit sharing guideline of 2014 issued by the Ministry of Environment, Forest and Climate Change. And in this case, the Uttarakhand High Court clarified that fair and equitable sharing provisions apply equally to Indian and the foreign entities. So this is also one of the major source in the arena of the biodiversity conservation to be agitated upon in the regime of adjudication of biodiversity dispute and its redressal, that Indian company is reeling under a misnomer that they are not supposed to seek, and the law is only applicable to the foreign countries and not Indian countries. That kind of a confusion and that kind of misnomer is being set at rest by the Uttarakhand High Court in case of Divya Pharmacy versus 2018. Thus, as a whole, we see that the biodiversity conservation, assuming as one of the most litigated area, because India's being as one of the 12 mega biodiversity region spread to 6 major biodiversity regions of the country, will essentially lead to some major crisis in the environmental dispute resolution mechanism, and we require that, since it is one of the litigated area, we require a very effective adjudication of biological diversity dispute, its settlement and redressal, to give effect of the three fundamental principles: the one, the sovereignty over natural resources, sustainable use, and equitable benefit sharing. That fundamental objective should not lose sight in the entire sphere of the adjudication of biological diversity dispute settlement and redressal. With this, I thank and I wish you happy learning.